Both LLPs and private limited companies offer limited liability protection, meaning your personal assets are protected from business liabilities. But beyond that fundamental similarity, they differ significantly. Should you set up a private limited company or a limited liability partnership, commonly known as an LLP? How do you decide which structure is right for you? That choice depends on understanding the key differences between these two structures. Your choice should be driven by your sector, your growth plans, and your appetite for compliance. Hello, and welcome back to the Veyrah Law series. In our previous episodes, we discussed various aspects of investing and operating in India. Today, we're going to tackle a fundamental question that every foreign investor faces when entering the Indian market. Should you set up a private limited company or a limited liability partnership, commonly known as an LLP? My name is Ajay Joseph. I'm a partner at Veyrah Law. We're a law firm based in Mumbai, India. You can find more information about me and Veyrah Law on our website. The link is in the description below. As usual, before we get started, a quick reminder. Please read the disclaimers carefully. With that out of the way, let's start with some context for our topic. Post 1991, when India opened up its economy, for quite some time, a private limited company was the only structure available to foreign investors who were looking to set up operations in India. The LLP structure was introduced much later under the LLP Act of 2008. Initially, foreign direct investment into LLPs was restricted. However, over time, regulations evolved, and today, foreign investment into an LLP is allowed, provided the sector in question does not have specific restrictions or conditionalities. So now foreign investors have a choice, and that choice depends on understanding the key differences between these two structures. Generally, both LLPs and private limited companies offer limited liability protection, meaning your personal assets are protected from business liabilities. But beyond that fundamental similarity, they differ significantly. Let's break down the major differences. First, let's talk about compliance framework. This is one of the biggest practical differences between the two structures. An LLP has a relatively light regulatory framework. The main annual filings are straightforward: a statement of accounts and solvency, an annual return, and your income tax return. That is it. This simplicity translates into lower compliance expenses and less time spent on regulatory paperwork. In contrast, a private limited company operates under a much more stringent compliance regime. You need to file financial statements, annual returns, auditor appointment forms, and KYC updates for directors, just to name the regular ones. Beyond that, there are multiple event-based filings triggered by routine corporate actions, such as changes in shareholding, board composition, registered office, and so on. The compliance calendar for a company is significantly more demanding. Next, audit requirements. For an LLP, audit is required only if your turnover exceeds 40 lakh rupees or your capital contribution exceeds 25 lakh rupees. Below those thresholds, you can operate without a statutory audit. This keeps expenses low for smaller operations. For a private limited company, statutory audit is mandatory, irrespective of your turnover or capital. Even if you are a small company with minimal activity, you must have your books audited every year. Next is taxation. This is where things get interesting. For financial year 25-26, LLPs are taxed at a flat rate of 30% plus applicable surcharge and cess if income is less than 10 million rupees, and around 34% all-inclusive where income exceeds 10 million rupees. The good news is that when partners withdraw profits from the LLP, those distributions are exempt from tax in the hands of the partners. This means there is no economic double taxation. The LLP pays tax once and the partners receive their share tax-free. Companies, on the other hand, benefit from a comparatively lower base tax rate. If your turnover is up to 400 crores, the tax rate is 25%. Above that, it is 30%. However, dividends are taxed in the hands of shareholders, which creates an additional layer of taxation. So while the base rate is lower, the overall tax structure is more complex. Another critical difference is governance in day-to-day operations. An LLP offers significant operational flexibility. Management is flexible, partners can manage the business directly without the need for a formal board structure. Decision making is based on what is agreed in the partnership deed. It can be consensual or structured depending on what the partners choose or agree. Contracts can be signed by partners on behalf of the LLP. Adding or removing partners is relatively simple with mutual consent. There are no mandatory meetings, no board resolutions for routine decisions, and no rigid governance formalities. A private limited company operates within a formal governance framework. You must have a board of directors that oversees management. Major decisions require board resolutions. You must hold at least 4 meetings of the board of directors every year, plus an annual general meeting. Minutes, registers, and resolutions must be maintained meticulously. Contracts require authorized signatories to be formally designated. Adding or removing shareholders involves share transfers, documentation, and regulatory compliance. This formality enhances transparency and credibility, but it also increases the administrative burden. Finally, and this is crucial for growth-oriented businesses, funding and investment options. LLPs are generally less attractive to external investors. Why? Because there is no traditional equity structure. Venture capitalists, angel investors, and institutional investors generally prefer the shareholding model that companies offer. It is familiar, it is standardized, and it is much easier to structure investments and exits. Additionally, foreign investment into LLPs is restricted. It's allowed only in specific sectors where there are no entry conditions or restrictions. Private limited companies, by contrast, are the preferred structure for raising capital. Equity funding is straightforward, investors understand the shareholding model, and regulatory clarity makes it easy to bring in capital. Foreign investment is permitted under the automatic route in most sectors. If you plan to scale your business and bring in external investors, a company structure is almost always the right choice. So, how do you decide which structure is right for you? Here is our position on this. First, check if your sector permits foreign investments into LLPs. If the sector has restrictions or conditionalities on foreign investment, an LLP is not an option. It's a no-brainer. You will need to set up a company. But if your sector does permit LLPs, then the choice comes down to your business needs. Choose an LLP if you're running a closely held business or a professional services firm. You want lower compliance costs and operational flexibility. You don't plan to raise external funding from venture capitalists or institutional investors. You prefer simpler governance without board meetings and formal resolutions. Choose a private limited company if you plan to scale the business and raise external capital. You want to attract venture capital, angel investors, or institutional funding. You are comfortable with the additional compliance and governance requirements. You want the credibility and structure that comes with a formal board and shareholding model. Here is a practical tip. Setting up an LLP from scratch can sometimes involve delays. In the early years, when company incorporation was a time-consuming process, a common workaround was to purchase an existing shell company and make the necessary changes. The same approach can work for LLPs. If speed is important, consider acquiring an existing LLP and modifying it to suit your needs. This can save you time and get you operational faster. But this also brings with it risk of historical liabilities. To sum up, both LLPs and private limited companies offer limited liability protection. LLPs offer lighter compliance, simpler governance, and tax-free profit distributions to partners, but limited fundraising options. Companies come with heavier compliance and formal governance, but offer better access to capital and tax planning flexibility. Your choice should be driven by your sector, your growth plans, and your appetite for compliance. As the saying goes, Complexity compounds faster than cost. On that note, we hope this video gave you some clarity on the LLP versus company decision when setting up in India. If you found this video useful, please do share it with others who may benefit. And as always, if you have questions or topics you would like us to cover, drop them in the comments below or send us an email. Someone from the team will surely get back. Thank you for watching and see you in the next video.